In 1982, a sophomore at the University of Texas named Gregory Watson needed a topic for a government paper. He went looking through the Constitution's failed amendments, the ones proposed but never ratified, and he found something strange. There was an amendment about congressional pay, proposed in 1789, that had never been formally killed. No deadline, no expiration, just sitting there, unratified, for nearly 2 centuries. His paper argued it was still technically pending, and that the states could still ratify it today. He got a C. He was right. 10 years later, that amendment became the 27th Amendment to the United States Constitution. That is the best story in the Constitution, and it is completely true. But it is not actually the interesting part. The interesting part is what the amendment does once you have it. Because after 202 years of waiting, after a student letter writing campaign that took a decade, after 38 states finally lined up, the country got a provision that turns out to constrain Congress almost not at all. So the question for this primer is that gap. The 27th Amendment took longer to ratify than any provision in American history. What does it actually do? This is Do It for the Case Law. Doctrine Deep Dives. Season 0. The Amendments. One at a time. One sharpest gap each. Today, the 27th. Start with the text, because it is one sentence and every word of it matters. No law, varying the compensation for the services of the senators and representatives, shall take effect until an election of representatives shall have intervened. Read that again and notice what it does not say. It does not cap congressional pay. It does not say pay may not rise. It does not require a vote of the people, or a commission, or any outside approval at all. It says one thing: a law changing congressional pay cannot take effect until an election of the House has happened in between. Congress may vote itself a raise. It simply cannot collect that raise until the voters have had one chance to respond. It is worth dwelling on the word varying, because it is the word the whole provision turns on, and it is doing more work than it looks. Varying means changing, up or down. The amendment is symmetrical. A law cutting congressional pay is caught by it exactly as much as a law raising congressional pay. That surprises people, because the amendment is always discussed as an anti-raise measure, and its politics are entirely about raises. But Madison was not writing an anti-raise rule. He was writing a rule against self-dealing in either direction, which in his era included the worry that a legislature might slash its own pay to make office affordable only to the wealthy. The text still carries that symmetry, whatever the politics around it have become. That is the whole mechanism, and the theory behind it is elegant. James Madison wrote it, and it was part of the original package of amendments sent to the states in 1789, the same batch that produced the Bill of Rights. 12 were proposed, 10 were ratified immediately, and became the first 10 amendments. 2 were not. One of those 2 concerned the size of congressional districts, and has never been ratified to this day. The other was this one. The idea was accountability by timing. If you want more money, fine, but you must face the voters before you touch it. They get to know what you did and decide whether you keep the job. The delay is the discipline. And notice the choice of trigger, because a different one was available. The amendment could have said a pay change requires approval by some outside body. It could have said a maximum. It could have required a supermajority. Any of those would have been a substantive constraint, and any of those would have been harder to satisfy. Instead, it uses time, and specifically it uses an election. That is the least intrusive possible check. It does not second-guess the amount. It does not add a veto. It does not involve anyone outside Congress at all. It simply inserts the voters between the decision and the money. That is a real design philosophy, and it is characteristically Madisonian. Do not forbid the self-interested act. Make the actor answer for it first. It is worth being clear about how a proposed amendment actually reaches the Constitution, because the whole story depends on the mechanics. Article 5 gives 2 paths, and only one has ever been used. Congress proposes an amendment by a 2/3 vote of both chambers, and it becomes part of the Constitution when 3/4 of the state legislatures ratify it. 38 states at present count. Notice what is absent from that description. There is no time limit anywhere in Article 5. A deadline, when one exists, is something Congress chose to write into the proposal itself. It is a policy decision, not a constitutional requirement. So an amendment proposed without a deadline is not operating under some grace period that eventually lapses. It is operating under no clock at all. So why did it fail in 1789? Not because anyone thought it was a bad idea, it simply did not reach the threshold. 6 states ratified it early, and then it stopped, and the country moved on to 200 years of other business. And here is the quirk that made the whole later story possible. Congress had not yet developed the habit of attaching deadlines to proposed amendments. Modern proposals routinely carry a 7-year window, which is why a proposal that stalls simply dies. This one carried nothing. No deadline meant no expiration, and no expiration meant that, at least arguably, it stayed open forever. For nearly 2 centuries, nobody tested that. Ohio ratified it in 1873 as a protest gesture. Wyoming did the same in 1978. Then nothing. Then came the C paper. Watson's argument was straightforward. No deadline, no death. The amendment was still live, and any state that ratified it was casting a valid vote. His instructor disagreed and graded accordingly. Watson, unpersuaded, started writing letters to state legislators one at a time on his own money and his own time. And it worked. Through the 1980s, state after state ratified. The politics helped enormously because congressional pay was unpopular in exactly the way that makes a legislature want to be seen doing something about it. In May of 1992, the 38th state ratified, and the amendment crossed the three-quarters threshold, 202 years, 7 months and change, the longest ratification in American history, by a margin that is not close. There was a genuine constitutional question buried in all of that, and it deserves naming rather than skipping. Can a ratification cast in 1992 be combined with one cast in 1789 to make a single valid amendment? The Supreme Court had said decades earlier that ratification should reflect a contemporaneous consensus, that the states agreeing ought to be agreeing at roughly the same moment about the same thing. 2 centuries is not roughly the same moment. That objection was raised. It was also, in practical terms, overtaken. Congress passed resolutions treating the amendment as ratified. The archivist certified it, and it was printed as part of the Constitution. Nobody has successfully unwound it since, which is its own quiet lesson about how constitutional questions actually get settled, sometimes not by resolution, but by everyone acting as though they are. There is one more piece of the ratification story that belongs here, because it complicates the tidy version. The amendment was not ratified by a country newly persuaded of Madison's timing principle. It was ratified during a period of intense public anger at Congress, when state legislators found that voting for it cost them nothing and bought them a headline. Several states ratified within weeks of each other in that atmosphere. So the coalition that finished the job in 1992 was not the coalition that started it in 1789, and it was not agreeing to quite the same thing. The founders' version was about structural self-dealing. The modern version was about being seen to punish Congress. The text they ratified was identical. What they thought they were doing was not. Now to what it does, which is where this episode turns. The amendment has been litigated, and the cases are the clearest available evidence of its reach. The leading one is Boehner versus Anderson, decided by the D.C. Circuit in 1994, 2 years after ratification. It is, so far as the record shows, the first case requiring a court to interpret the 27th Amendment at all. Congressman John Boehner challenged the mechanism by which congressional pay rises automatically each year through a cost-of-living adjustment, arguing that those annual increases were laws varying compensation taking effect without an intervening election. The court held he had standing to bring the challenge, and then it rejected it on the merits. The reasoning is worth understanding, because it is the hinge for everything after. The pay adjustment mechanism had been created by a statute enacted before an election of the House. That statute set up a formula, and the formula then produced raises year after year automatically. The court's view was that the law varying compensation was the original statute, and that statute had satisfied the amendment. An election intervened between its enactment and the point at which it began operating. The annual adjustments that flowed from the formula afterward were the operation of an already compliant law, not new laws each time. Sit with what that means. Congress can satisfy the 27th Amendment once by passing a formula and then receive automatic raises indefinitely without ever facing the amendment again. The court also declined to reach a related challenge to the quadrennial pay raise mechanism, holding it was not yet ripe, and the district court below had reached the same merits conclusion 2 years earlier, granting summary judgment for the government on the ground that the statutory methodology satisfied the amendment because an election had intervened before the mechanism first operated. So within 2 years of ratification, the amendment's central practical question had been answered, and answered against the challenger. A formula enacted once, before an election, can generate raises forever. The 200-year gap also created a problem nobody had needed to solve before. Who decides when an amendment is ratified? The answer, by statute, is the Archivist of the United States, who certifies that the requisite states have acted. That is an administrative function, not a judicial one. There is no court that blesses an amendment, and no moment at which someone rules on its validity. Which means that in 1992, the question of whether a 2-century ratification counted was answered by an executive branch official performing a ministerial duty, and then ratified after the fact by congressional resolutions endorsing what had already happened. That is not a criticism of anyone involved. It is a description of how thin the machinery is at exactly the point where you might expect it to be thickest. Then the second case, and it fails on an entirely different ground. In 2001, in Schaffer versus Clinton, the 10th Circuit heard a sitting member of Congress raise essentially the same challenge to automatic cost of living increases. The district court had rejected it on the merits. The 10th Circuit did not reach the merits at all. It held the member lacked standing to bring the suit, and dismissed on that basis. So now there are 2 federal appellate decisions on the 27th Amendment, and they disagree about whether a member of Congress can even get through the courthouse door. The D.C. Circuit said yes. The 10th Circuit said no. The disagreement matters more than it might seem, and here is why. The 27th Amendment protects a very unusual interest. Its whole subject is the pay of members of Congress. The people most obviously affected by a violation are the members themselves, and the voters, diffusely. If members lack standing to challenge their own compensation, and ordinary voters have only the generalized grievance that courts routinely refuse to hear, then you have an amendment whose violations may be, as a practical matter, unreviewable. Not because the rule is unclear, but because it is not obvious anyone can be in a position to enforce it. That is a different kind of weakness from the one in the Boehner holding, and the two compound. It is worth pausing on how unusual it is for an amendment to be interpreted for the first time 2 years after it joins the Constitution. Most provisions arrive with decades or centuries of accumulated argument behind them. This one arrived essentially cold 200 years after it was drafted, into a legal world its author could not have imagined, with automatic cost of living formulas and indexed federal pay schedules that had no analog in 1789. And the very first question put to it was whether an automatic formula counts as a law varying compensation. Madison had no view on that, because the concept did not exist, so the court had to decide what a timing rule written for discrete acts of legislation means in a world of standing mechanisms that legislate once and then run by themselves. It answered, the mechanism is the law, and it only has to clear the amendment once. The third case narrows it further, and it is recent. In 2022, in Massey v. Pelosi, members challenged fines that the House had imposed on them and deducted from their pay. The argument was that a deduction changes what you receive, and therefore varies compensation within the meaning of the amendment. The district court disagreed, holding that compensation refers to the salary fixed by law, not to the net amount that actually lands in someone's account after deductions. The House had not changed anyone's salary, it had imposed a penalty against a salary that stayed the same. The D.C. Circuit affirmed the following year. So the amendment reaches the number on the statute, not the number on the paycheck. Put those three together, and the picture is consistent. Every reported challenge under this amendment has failed, and each one failed in a different way. Boehner failed because a formula enacted once, before an election, keeps working forever. Schaffer failed because the person best positioned to complain was held to lack standing. Massey failed because a deduction is not a variation. That is not a doctrine that has been narrowed over time by a hostile court. It is a provision that has been read, more or less straightforwardly, and turned out to have very little in it. So here is the thesis. And it is unusual for this show because the shortfall is not really the court's doing. Most of our episodes find a broad promise that judicial doctrine has quietly narrowed. The 27th is different. Its text is modest, by design. Madison did not write a cap on congressional pay, he wrote a timing rule. The amendment does exactly what its words say, and its words say very little. The distance here is between the amendment's reputation and its content. It is remembered as the Accountability Amendment, the one that stops Congress from voting itself raises. It does not stop Congress from voting itself raises. It delays collection by one election, and it can be satisfied permanently with a single well-timed statute. There is a structural reason all three cases came out this way, and it is worth naming because it is not about any court's hostility. The 27th Amendment is a procedural rule about timing. Procedural rules are satisfied or not, and once satisfied they are done. They do not have a substantive core that keeps applying, the way an equal protection or due process guarantee keeps applying to every new situation. So an amendment built on timing is inherently a one-shot check. Clear it, and it is behind you. That is not a loophole anyone exploited. It is what a timing rule is. Which means the most useful way to read the Boehner holding is not as a narrowing of the amendment, but as an accurate description of what kind of instrument the amendment always was. One more practical note about what the amendment does not touch, because it explains why congressional pay is not actually a live legal fight. The amendment governs laws varying compensation. It says nothing about the many other ways federal officials are paid: allowances, staff budgets, travel, the office accounts that make up a substantial part of what a congressional office costs. Those move by ordinary appropriation, and are not compensation in the amendment sense. So even a fully effective 27th Amendment would only ever have reached the salary line. The rest of the money was never within its scope. That is not a failure of the amendment. It is a reminder that a provision aimed at one narrow mechanism leaves everything adjacent to it untouched, and the adjacent things are often larger. And there is a second, sharper way to say it. The 202 years are not incidental to the story. They are the story. A provision sat unratified for 2 centuries because nobody cared enough to finish it, and then got ratified in a decade because congressional pay became a convenient thing for state legislators to be against. The amendment's ratification was itself a piece of political theater about accountability, and what it produced was a rule that provides very little accountability. The energy went into passing it, not into examining what it would do. That is worth remembering the next time an amendment is proposed as a solution to something. Ratification is the hard part, and it gets all the attention. Whether the text actually does the work is a separate question. and it is the one that survives after the celebration. So what would an effective version have looked like? Would have had to constrain the amount, not the timing, a cap indexed to something outside Congress's control, or a requirement that any increase be approved by a body Congress does not appoint, or a rule that a raise cannot take effect for the Congress that voted it at all, only for its successors. That last one is instructive, because it is very close to what people believe the 27th Amendment says. It is not what it says. The amendment requires an intervening election. It does not require that the members who voted for the raise be excluded from receiving it. A member re-elected at that intervening election collects the raise they voted for. The check is that the voters had a chance to stop them, not that they were stopped. None of which makes it worthless, and it would be unfair to leave it there. A one-election delay is a real constraint at the margin. It means a Congress cannot vote itself money in December and collect it in January. It forecloses the most naked version of the abuse, the one Madison was actually picturing. And it does so permanently, without depending on anyone's restraint. The amendment is a floor, not a ceiling. The mistake is expecting a ceiling from a sentence that only ever built a floor, and there is something genuinely valuable in its existence beyond its operation, which is the demonstration that the Constitution's amendment process has no statute of limitations unless one is written in. That is not nothing. It is the reason a student with a C could change the founding document. And there is one more thing this amendment quietly proves, which has nothing to do with congressional pay. When Watson was writing his paper, the received wisdom was that a proposed amendment left unratified was effectively dead. Everyone assumed it. Nobody had checked, because there was no reason to. He checked, and the assumption turned out to rest on nothing. Not on a rule, not on a case, not on a deadline in the text, just on the fact that it had always been true so far. That is a lesson worth more than the amendment itself. A great deal of what people confidently believe about the Constitution is not a holding, and not a text, but an inference from what has usually happened. Those are the beliefs worth testing, and testing them occasionally changes the founding document. It did here, for the cost of a stack of letters and a decade of a man's spare time. It also leaves a live thread, and it is a genuinely open one. The other unratified amendment from Madison's original 12, the one about the size of congressional districts, is in exactly the position the 27th was in before 1982, proposed in 1789. No deadline, never formally killed, ratified by a handful of states long ago, by the same logic that made the 27th Amendment part of the Constitution. That one is arguably still pending too. It would need a great many more states, and its subject matter is far more consequential than a timing rule about pay, since it would speak to the size of the House of Representatives itself. But the precedent for how it could happen now exists, and the person who established it got a C for suggesting it. That is the sample. A full Amendment 27 season on this show would take each thread in turn. Madison's original 12 and why 2 failed, the 2-century dormancy and the contemporaneous consensus objection, Gregory Watson's campaign, and what it says about who can amend a constitution. The Boehner line, and how a formula satisfies a timing rule permanently, the standing split between the D.C. and 10th Circuits, and whether anyone can enforce this amendment at all, and the still unratified Congressional Apportionment Amendment from the same original package, which is technically as alive today as this one was in 1982. One question per episode, each anchored in cases we verify, not cases we remember. A word on how this show works. Everything you just heard is legal and historical education, not legal advice, and every case in it is real, named, and verified against the public record before it was written. Boehner versus Anderson in both the District Court and the D.C. Circuit, Schaffer versus Clinton in the 10th Circuit, and Massey versus Pelosi in the District Court and on appeal. Their holdings are described here rather than quoted, and that distinction is deliberate. Where we quote verbatim from the opinion, and where we summarize, we say so. That is the whole ethos, and it is the name of the show. Do it for the case law. I'll see you at the next amendment.